Hey, good morning, folks. I'm attorney Roger P. Foley. It's, 7:20 or so in the morning, and I'm driving to court. Wanted to say hello and share a tip. I think this tip is really more for prosecutors and criminal defense attorneys, but, who am I to tell a prosecutor how to prosecute? But yesterday I went and I watched a case. And it was a stand your ground motion. And there were, there were 5 witnesses to the case. And I'm going to walk you through the facts, all right? So, the first person gets up, and he is, quote, the alleged victim. And the alleged victim says, I'm sitting at the bar, the restaurant. I just get my food, and someone taps me on the shoulder. Hadn't said anything to them, hadn't had any conversation with them. I got a tap on the shoulder. I turn, and I get punched in the face. And the only thing I remember is standing outside, and my nose was covered in blood. Okay. Now, even though that person had given testimony, it was fairly similar, but basically said I was, eating my soup and I got sucker punched. The cross-examination was limited, and honestly, I tend to agree with the attorney that was doing the defense on this. Keep it short, keep it simple, and move on. Right? You're never going to argue in cross-examination if you're doing it properly. Sometimes less is more. Now, the second person, I don't know, fiance, a spouse, gets up and says, I had some conversation with with the other party, and I had asked them to move down a little bit to give me more space. And I don't remember if they moved down or not. I honestly don't recall. But ultimately, one of the people in the party walks over and sucker punches my husband. Quote, sucker punches my husband. All right. There's a little bit of cross-examination in regards to the time that the incident happened. So the incident, the police are called in the evening. Let's just say for argument's sake, it's 9 o'clock at night. And according to the girlfriend, the spouse, the fiance, whatever it was, they arrived about 5:30, and they had only been there about 10 minutes when the incident occurred, right when the fight occurred. Part of the cross-examination is to have them take a look at the police report, and it was used to refresh the recollection. And I don't know if I would have done impeachment that way, but it was effective. There was no objection to it. And the fiance or whatever says, yeah, police were called at 9 o'clock-ish. Now, and then the defense attorney sat down. Again, a lot of times, folks, going to attorneys out there, keep it simple, stupid. The KISS acronym is a good way to go in cross-examination. And in this case, I think it was effective, because it automatically started to show that there was some time disparity, right? Because they're saying that at 5:30 they sat down, and only 10 minutes had gone by, and there was a fight where the man gets sucker punched. So obviously, if they're testifying that it was 5:30 and the police are called at 9 o'clock, they didn't call the police, right? Three and a half hours later, right? So, end of cross-examination. Next step. Defense calls its first witness, and they call the spouse of the defendant. Spouse of the defendant, was it this? Yep. Let's see, 1, 2. Yep. Calls the spouse of the defendant, gets up there. Defense attorney asked during direct examination, show me, outline to me where you were sitting. They were sitting at a bar. There was basically it was where the L of the bar is, right? So some of the parties sitting on one side of the L, some of the parties sitting on the other side of the L, but right where the bar comes to an intersection, a point, right? The end of the bar, I would say. Outlines that. Asks the defendant's spouse, had you been drinking? Yes, I had. Over a period of about 5 hours, there was a pool table, there were some other things going on, there were some activities that you could do there. I was doing that. I had a beer, then I had some water, then I had some beer, and I had a salad, and etc. Were you impaired? No. Ask questions about impairment. Good, kind of shows the person has a good memory. This person has credibility. They're not saying, well, they were sitting in a bar and didn't have anything to drink. I forgot to say, that question was asked of the spouse on cross-examination, and of the other spouse, sorry, the fiance, in the state's case in chief. And they said, no, I had ordered a drink, but I hadn't drank yet. Had you had anything to drink prior? No, I hadn't had anything to drink prior. Okay. So anyway, we're going back to defense case in chief. Asked the spouse. Spouse goes, yeah, I had a few drinks, definitely. Had 4 beers over that time period. All right. What did you see during that time? Well, during that time, the victim's spouse asked me to move down, so I moved down. And then apparently I didn't move down enough, and I was elbowed, right? I was struck, I was battered, and an argument ensued. And I said, what are you doing? And I cursed. Cross-examination, the prosecutor tries to confuse the witness in regards to the seating chart and say, well, based on this, didn't you? No, my husband came over and moved, tried to de-escalate and move me out of the situation from arguing with the woman who had just, elbowed me. Okay. Any redirect? No redirect. Defense calls their second witness. Their second witness is a bartender, the bartender that was serving the parties. And again, it's the defense's case in chief, so the defense does a direct. Tell me where you work, how long have you been working there, who did you see sitting at the bar, how many people were in the bar, was it crowded? Yes, it was. I saw the defendant, his wife, and another 3 people in their party, and then I saw the victim's fiance, and another couple. Okay. And what, if anything, did you notice about the defendant? Did he appear intoxicated? No. What about the victim? Very intoxicated. Did you serve him? No, I hadn't served them. They arrived at the bar drunk. Okay. So now you're getting the information. What did you see? Well, I actually saw the victim's wife elbow the defendant's wife, right, the two women, and I immediately yelled for management because I could see that this was getting out of hand. Right as I did that, I turned around and I saw the defendant walk over and try to separate the two women. What happened next? What happened next was the victim said to the other man's wife, "Shut the F up." And what happened next? Well, the defendant said, "Hey, buddy, are you talking to my wife?" One of those situations. And then what happened? Well, then the victim said, "I'm gonna kick your ass," spun his chair around and started to get up with his hands up. What happened next? The defendant punched him in the face. Okay. How close of a distance would you say the defendant was from the victim? It was 2 feet, 2 feet. 2 feet, yeah, about the width of a chair. Okay, thank you. Sits down. Cross-examination. The state attorney asks some questions, and those questions are not how many drinks did you serve the defendant. Doesn't ask anything about that, which I thought was surprising. Asks questions about the seating chart and says, "Well, show me the seating chart. How many seats were between the victim and the defendant?" There's about five seats or so, maybe 6 seats. Okay, how close are they? They're all they're literally right next to each other, so they're about a foot, if not even a foot apart. The seats actually they literally touch each other. Okay, so you're saying that between where the victim was sitting and the defendant was sitting, there was only 2 feet? No, that's not what I'm saying. And then the witness proceeds to say, no. When the elbow occurred, the defendant got up and walked over and put his hands in between the two women and then was pulling his wife out. Yep. And then he just hit the other guy for no reason. No, that's not what I said. I said that the defendant walked over, got in between the two women. The other man shouted, "Shut the F up." There was a dialogue, and the victim went to stand up with his hands up and said, "I'm going to kick your ass." And as he started to stand up and he stood up, he got punched in the face. Okay? The prosecutor really couldn't do much with that testimony. Sits down. Thank you, that's all. Right? No real redirect. It wasn't really needed. Maybe just to go over the alignment of the seats again. Defense now calls its third witness, the actual defendant. Part of me was going, I don't know that we need that right now, but yeah, you know what? The defendant was a good witness. He gets up on the stand. They go through his background. He's a retired, individual, and says, "Tell me what happened." I arrived at the bar about 5:30. My wife and one of her friends were already there. They were, doing activities, like I said, playing pool and these kinds of things. And they would leave and then come back, leave and come back to the chairs. Did someone else arrive? Yes, I believe another couple arrived. Did you notice that there was any argument? Did anything happen? No, I didn't really notice anything. Were you aware that there was cross conversation, that there was some issue about moving over? I really didn't hear any of that. I know there was at one point that I moved down a little bit because everyone was moving down, so I moved down, but I didn't really hear what conversation had occurred, if any. Didn't notice anything wrong. What happened later? Well, a while later, the person sitting next to me, kind of pointed like, hey, there's something going on. And I look over and I see another woman elbow my wife. Well, what do you do then, sir? Well, I walk over, and the seats are so close, and the women are, bickering, that I try to de-escalate the thing by, I'm standing behind them because the seats are actually so close, I can't get in between. So I'm actually standing behind, and I'm trying to get my wife out. So I'm kind of standing more behind, the victim's wife, because I'm trying to get my wife out of that situation and away from it. What happens then? Well, a man that I really hadn't noticed shouts, "Shut the F up." And I'm like, I think he's talking to my wife, because my wife was the one talking, and she was saying something, to the other woman at that time. So I said, hey, excuse me, sir, are you talking to my wife? Because, there's a possibility he might have been talking to his own wife. And at that moment, the man says loudly, I'm going to shut up. No, he says, I'm going to kick your ass, spins in his chair, moves his fist, and starts to come at me. What do you do? Well, as soon as he gets up, I punch him right in the face. Okay? Well, how close were you? We were really close. Well, did you walk over to him to start a fight? No, sir. I walked over. I didn't really even realize that he was involved. So what happened next? Did you keep punching him? Did you finish the? No, I hit him, and I immediately backed up, 3 or 4 feet with my wife behind me to a safe distance. Then what happened? Well, employees came out and got in between us, and everybody was escorted outside. The police arrived. Yes, they did. Did you speak to the police? Yes, I did. Did you give a statement to police? Yes, I did. Did you give a written statement? Yes, I did. I'm going to show you something. Can you tell me what this is? Can I show it to defense? Can I show it to the state? Yes. They publish it. Can you tell me what it is? That's the statement that I wrote. And in that statement, did you explain to the officer that the person told you that they were going to, kick your ass? Yes, I did. Did you write it in a statement? Yes, I did. Is this a true and accurate depiction of the statement? Yes, it is. This looks like the statement. Okay, judge, I'd like to enter it. Now they enter the statement. Okay, that's all cross-examination. The state proceeds to ask questions again about this seating chart. The seating chart's pretty established. There's the defendant's wife is 1, 2, 3, 4 seats from him, and then the other party's on the other side of her. And the prosecutor's trying to say, well, you walked over to this man to punch him in the face. He didn't have any conversation. No, sir, that's not accurate. I walked over to de-escalate what was going on between the two women. I really wasn't cognizant of what was going on, if anything, with the man. I mean, maybe they were together, maybe they were. I really, I wasn't paying attention to the person until I heard a yell, "Shut the F up." And I looked at the guy, and he looks at me, and I go, "Excuse me, are you talking to my wife?" And then the guy says, "I'm going to kick your ass." And he, spins his chair around and stands up. You're sure he stand up? Yes. Well, you didn't say all that in the police report. He said, "I'm gonna kick your ass," and came towards me, and Well, you didn't say that he stood up in the report. He was in the process of getting up. He just said he was going to kick my ass, and he came at me. But you didn't say it. No, that's what I said. All right, that's all I have. Redirect. Sir, can you tell me how far distance? I just want to make sure what was the victim kind of obvious, but let me ask you this question. What was the victim close enough to you to hit you? Yes. Close enough for you to hit back? Yes. Thank you. That's it. Closing argument. State goes first. State says, this is where the legal analysis comes in, folks. This is where other attorneys need to be careful. The prosecutor in this case had written out his closing argument. He included the statute, the stand your ground statute, and I don't know it off the cuff, but and some case law. Started with that sort of memorandum of law, and then read from a prepared statement. And I'm sitting there in the pews, and I kind of lean forward. I'm like, what is he doing? And he proceeds to read the facts, and the facts are: my client was sitting in a bar. Someone taps him on the shoulder. He turns to look, not knowing who it is, and he gets sucker punched. And I'm thinking, like, I know that your client said that, but, and I know his wife said that, but there was no account in the state's argument or presentation back to the court of the facts that demonstrated that not only did the defendant say that's not how it happened, which, I get it, conflict in the facts, that the defendant's wife said it didn't happen that way. Okay, possibly, didn't even say, hey, well, maybe the court shouldn't look at the credibility. It's his wife, right? Didn't ask those questions on cross-examination of like, hey, it's your husband, right? You love him, and you would do anything for him. There were no questions to that effect. I mean, it was sort of mind-boggling. There was no questions from the state about how many drinks that the defendant had. Kind of weird, right? Nothing about his memory. So that the state just reads from a couple of pages and just kind of read it. And the most important thing is the state did not account for the third-party witness, meaning the bartender that served them. Never even asked the bartender, do you know these people? Are you friends with these people? Have you ever met these people before? Never asked those questions. But forgets to mention anything that a third-party witness, and neither side asked that question. Kind of odd to me, like, because I would want to know if I was the court, and the court didn't ask the question, because I think if I was the judge, I probably would have said, like, ma'am, just a quick question. Do you know any of these people? Are you friends with any of these people? Because I'd want to make sure that there was no bias, right? What if the defendant was best friends with the, with the bartender, or vice versa? Like, I want to know that. Neither side, asked that question. So, I mean, I literally sat up and I'm going, is he just going to read? Like, there was no, like, Your Honor, you heard the testimony. I'm not going to overly do it, but some key facts I want you to realize. But now the defense gets to go. And the defense does do that. And that's where the defense, I think does a solid job. And another part was reeling in the witness. The bartender started to kind of go off on we call him a runaway witness. If you're an attorney, you know what I'm talking about. And the bartender witness started to run off, and he literally was like a fish, right? Like when the fish pulls and you go and you reel the fish back in, right? Because it's pulling, and then you let it go a little bit, then you pull it in. Well, the runaway witness, you got to be real careful, because even though it's your witness, it could seriously harm your case. And that person started to blah, 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 stuff that's not relevant and kind of take off. Oh, no, hang on, stop a second. And he pulled the witness back in. So then the defense attorney says, Judge, this is pretty clear. I think if anyone's wife was insulted, well, if anyone saw their wife being battered, they would go over to, protect, defend, to de-escalate the situation. There's two women. And I'm not saying, Your Honor, that because my client's wife was battered by the spouse or fiance of the defendant, that my client has a right to punch him in the face. That's not what I'm saying, Judge. And I think that's the argument that the state seems to be to claim that I'm having. That's not the argument. What I'm saying is that my client walked over, tried to break up the bickering between the woman so it didn't escalate because there had already been a strike thrown. And at that moment, while he's doing that, while he's escorting his wife out of the situation, a man who is clearly intoxicated, who the bartender told you he came in drunk, said to him, I'm going to kick your ass, swiveled his chair, and stood up with the apparent ability to strike the defendant. And Judge, we've said victim throughout this case. I think the testimony reveals he's not a victim. He's a drunk guy that started a fight. He stood up and came towards the defendant. They may not have taken a step. There was no testimony of that, but they were already so close, Judge. My client was standing closer to his wife because he was trying to block so his wife could exit the chair because they were so close. You already heard the testimony. The testimony from the bartender is like 70 people at a bar that only fits 45. But when you hear the statements from the witnesses for the state, they say, oh, there's a bunch of chairs open. There was barely nobody there. Judge, it was 9 o'clock on a Saturday night at a bar restaurant. There was a lot of people there. You heard the testimony. Everyone said it. But the state, they don't know what time they got there, Judge. Their timeline's about 2.5 hours off. I would submit that wherever they were during that 2.5 hours, because it wasn't this bar, it was at another location where they were consuming alcohol. Because the bartender, who doesn't know anyone, and he said it, testified that the victim and his fiancé spouse were impaired. They even said that they were not given a drink, although they had ordered drinks. Defense sits down. Judge does, I wouldn't call it shocking, but the judge goes, all right, I'm going to take this all under advisement. I appreciate everybody's time, and I'll get you an order in the next week or so, and sets another court date. I understand why judges do that. I don't think that some judges, they don't want the conflict. But I disagree with that a lot. I think that it's pretty clearly obvious. I mean, I'm a defense attorney. Maybe I'm a little biased. I don't know. But I listened to all the testimony, and I tried to give it to you guys exactly how it was. And I look at it and I go, it's clearly a stand your ground. It's clear, but the prosecutor's argument was to read off a paperwork with no accounting of the testimony. He simply wrote what, I don't know, it's just odd to me. So I'll follow up on the case to see what the judge's result is. But I'm in the 99 percentile You always got to account for the fact that maybe the judge isn't learned, and doesn't know the law. But the case law is directly on point. If you're in fear and someone assaults you, verbally says, I'm going to do something, and then does an overt act to complete that, standing up with their fist to come towards you, that's a threat. And the testimony said that he didn't continue and punch him and kick him and beat him up, and it just struck him. He fell back into the seat. Thing's over. Backs up. Safe distance. But the judge said, I'll get back to you. So why do judges do that? Well, the victim is sitting in the courtroom. The defendant's sitting in the courtroom. And maybe the judge wants to be thorough and put all the case law in there, you know. Just the independent witness does it. But the judge doesn't want to have that confrontation to say that I found someone more credible or one side more believable than the other. I think it's easier to let the prosecutor, or a lot of times the defense attorney, they get a copy of the order, and then that individual or respective party says to their client, hey, the judge ruled against us. And it keeps it de-escalates the situation. There's an argument for that. I've also had where, like, it's such a Captain Obvious situation, and the judge rules against the person who you would think clearly is won. I've seen that happen, and you got to appeal those things, or go to trial, or if you're a defense, reserve your right to appeal and either take a plea or go to trial. I also see judges do it with police officers, and that's the time that it really bothers me. I've had cases, and I can remember a specific judge. I'm not going to say names, but I'm going to tell you it's in Broward County. And I had several cases. I had one case that was a drug trafficking case, and the officers, I clearly showed after I think it was 5.5 hour motion to suppress, that the police lied, that they didn't have a warrant, that they had begun their search, that they were opening up things on this person's property. And the great thing was my client had cameras, and although police often snag those things so we don't have that evidence, and it makes it difficult for us to acquire it if the police have taken it, and it miraculously is lost. I've had that. We had the video, so I let I don't know, 5 cops on the stand go, nope, we never looked in anything, we never tried a door, we never reached into a window, nothing. Each officer, and I know that that the state was thinking like, oh, it's a slam dunk. I mean, they didn't do anything fully, your motion's off. And then I used rebuttable evidence, the videotape, and I put my client up on the stand to say, I have a camera system. What kind of camera system is it? How many cameras are there? 16 cameras. Where are they? They're located outside of my house, along my property. Okay? And tell me the areas that they show. And I went through it, pool area, the shed. And there you go. You watch the cops opening up the pool supplies, looking in them, digging in them. You see them going into a shed that they just testified under oath that it did happen. And the police officers left. They didn't wait to listen. And the judge makes his ruling, and he says, motion granted, all the evidence is suppressed, and my client's drug trafficking case went away. I don't advocate drug trafficking, but I do advocate that police do it the correct way. And after the judge made his ruling, and this happened twice, the judge went off the record, said, we're off the record, turned off the blue light, and then said, those were the most non-credible officers that I've fully. This is the second case in a row that you've done that. Like, how are you finding these cases where police are just blatantly lying? I mean, he said blatantly lying. And you got to choose your battles. But I was mad with the judge. I was mad at the judge. And why was I mad at the judge? Because in my humble opinion, that judge is supposed to uphold the integrity of that court and of court system. And those 4 or 5 officers in my case, they clearly perjured themselves. I had them on video. I don't know. Couldn't the judge hold them in contempt of court? Couldn't the state attorney have filed corruption charges against them? Absolutely. You know what happened? Squat. Nothing. So I think that's when I get the most mad. Maybe in this situation, everyone's leaving the courtroom at the same time. We don't want to have a victor. We want everyone, in the case that I just talked to you about, the battery case. Maybe you just want to have everybody leave the courthouse thinking, hey, I did good, and then a week later, write the report. Okay, I can see that. I can see a possible argument for the judge, like, hey, just let everybody go in peace. Don't talk to each other, move on with your day. And then a week later, when everyone's separated, the judge gives the ruling. I guess I could see that. Anyway, I'm attorney Roger P. Foley, and stories from the courthouse. Take care.